Justice Barrett?
So, Ms. Harris, when you were going through with Justice Kagan the considerations in the Controlled Substances Act for winding up on one of the schedules, there are a panoply, right? And you can wind up for one reason and maybe not for another. Is proclivity to violence expressly one of the things that's taken into account in putting a drug on the schedule?
It is not in the statutory criteria. The way I do think it often works out is the DEA may provide evidence with respect to the drug in connection with crimes, but obviously it's not one of the fixed statutory criteria. Again, I don't think that's a problem for the reasons we've discussed, which is you also don't have findings with respect to the mentally ill or other categories.
I mean, I understand that. I think where I'm stuck, I agree with you that you don't need to have just alcohol because that's all there was at the finding, and that would be trapped in amber. Let's say that I think that the principle is if you have reason to know that someone would pose a risk of violence is dangerous, that the legislature can disarm. I guess when I look at these drugs, however, I mean, Robitussin, Ambien, Tylenol with codeine, testosterone, Adderall, I mean, none of those drugs strike me, I mean, I'm not a pharmacologist, but none of those drugs strike me as drugs for which it is obvious that a risk of violence would ensue. Is it your position that all of the drugs that I just mentioned would pose a risk of violence and dangerous behavior?
So what I'm saying is those drugs in Schedule 4 and Schedule 5.
Well, actually, Adderall is in Schedule 2.
Okay. Just with, yes, I'm sorry, I'm less familiar with Adderall on the scheduling. But with respect to these categories of drugs, whichever schedule they're on, you have to be using them habitually and not for their prescribed purpose. So yes, our position is if you are in that category, you are doing something that is.
So it's the lawfulness, because what if you're a college student and you take your roommate's Ritalin twice a week because you think it's going to help you take exams?
Yeah, and I think we're going to get to a place where you're into ketamine and other drugs, ketamine being Schedule 3, it's a lesser version of PCP.
So the problem is that if you take Adderall, then you slide into other drugs?
I think it is a problem of who decides what the adequate proxy for dangerousness is. And if you wanted to go on
But you said, I think it's clear when you look at the Controlled Substances Act, dangerous is not necessarily the primary reason why, or even a reason why all of these drugs land on the list. And so I guess my concern is, let's say that I think Congress could make a determination, maybe, I don't know. I mean, there was just an article in the New York Times about the dangers of marijuana, and maybe that's true. Maybe THC concentrations are higher nowadays, and that does have bad effects on, bad mind-altering effects, and maybe it gives rise to violence. I just don't see that, my concern, and maybe you can dispel it. My concern is I just don't see that that determination was made here.
I guess I would point you to, again, if you wanted comfort with respect to marijuana in particular, the whole history of rescheduling, the determinations made with respect to that substance, et cetera. And I think the other thing to consider is if
and where does it say that it leads to violence?
There are
history.
Well, first of all, I guess I would point to the court's cases, which many of which are cases in which there is a strong connection between marijuana use and violence. But I would just take a step back and say, if that is the key, if you have to have some determination that, say, the mentally ill or particular drugs present a risk of dangerousness as opposed to the common sense notion backed by all of this evidence, backed by these processes, that when you are frequently using these mind-altering substances, you are in the class of people who present a special danger of misuse just so long as you're habitually doing it. I think that's more of a guardrail. There's no such thing for habitual drunkards. No one was going around saying habitual drunkards are, as a class, unsafe because the justice of the peace isn't saying this particular habitual drunkard is too unsafe to do anything.
Actually, I'm glad you asked that. This is my last question. This goes back to your colloquy with Justice Alito, and you were talking about how as-applied challenges would be unworkable. What about as-applied challenges? Let's put aside the possibility of as-applied challenges being required as to each individual defendant, an as-applied challenge to Mr. Hemani in particular. What about an as-applied challenge just to that particular drug? Why can't Mr. Hemani simply say, you don't have to take into account all of my personal circumstances, but, government, I would like to put you to your proof about whether marijuana has an established link to violence.
Right, and I think if you look at the Third Circuit's opinion in Harris, the kind of questions that you would adduce to answer that question, unless you are not willing to accept a connection, the intuitive and historically grounded connection between intoxicating substances and the dangers they present and the idea that they are in fact dangerous and might lead to violence, I think you have a real problem with.
So the person with Robitussin shouldn't be able to, who's caught with Robitussin and uses it for coughing and sleeping, 3 nights a week, that person can't make an as-applied challenge.
I think the government is willing to entertain the idea, as we would with like sugar or caffeine, that if there is not sort of a factual record, but I think here, again, you can either carve out Schedule 5 or do some other things.
So you're not rejecting out of hand the possibility of as-applied challenges to the particular drugs, you're just resisting that it would apply as to marijuana?
I'm resisting the idea that it could be constitutionally required for Second Amendment purposes, because I think you would be fundamentally altering the Rahimi framework in a problematic way by discounting the ways in which the modern analog of 922G3 is more tailored and only focusing on the idea that you need like some exact comparator, as if you could go back in time and figure out exactly the mental effects of intoxication to figure out how violent someone is. I think that's an impossibility.